Good afternoon, everyone. Can you all hear me?
Yes, we can. Good afternoon.
All right, thank you very much. All right. Good afternoon, everyone. My name is Hussein Mahadi. I'm the moderator for today's session, and today is the week 3 of Jiipcc Mentorship and Internship Program on Intellectual Property, and the topic for today is IP registration, infringement, and enforcement. Today we have 3 mentors with us: Mr. Max Ikongwe, Mr. Christian Aniuku, and finally, Mrs. Omotayo Alemeu. Those are our 3 mentors today. We look forward to learning from them. Welcome everyone to the call. I'll be making a few announcements and also reading our mentors profile. Please, Dennis, you can help me share my screen. Thank you. All right, registration for next quarter, which is the first quarter of 2024, is currently ongoing for Jiipcc Mentorship Internship Program. The courses we have intellectual property, AI, energy industry, fintech, health tech and law, patent drafting, blockchain, NFTs and metaverse, data privacy and protection, and entertainment, business and law. You can share the flyer with your colleagues, your friends, your workmates, anyone who is interested in taking any of these courses. And you can also sign up for any of the courses you are interested in taking. And also, Jiipcc is providing the private mentorship session. So far, I don't know if any of you have a favorite mentor yet, but whenever you do, reach out to me or Dennis or any of the Jiipcc team members to help you through on how to register. You can just use the link on the flyer on your screen to register for the private 30-minute one-on-one session with your favorite mentor, where you can get life hacks, lessons, and directions from your favorite mentor on your project or your career ahead. All right, I'll be reading our mentor's profile. Mr. Max Ikongwe is the founder, principal of Evalo Associates. He works extensively in the field of arbitration, ICT technology law, and intellectual property. Max is a facilitator on the annual Information Technology and the Law course of the Nigerian Institute of Advanced Legal Studies since 2016. He has trained in advanced intellectual property law course at the JIIPCC office, JIIPCC Academy, and he is an accredited agent of the Nigerian Trademark and Patent Registry, and has conducted IP registration business since 2010. That's the profile of our first mentor. Welcome to the call. Our second mentor for today is our second mentor for today is Mr. Christian Aniuku. Christian is an experienced management consultant at EY in London. As part of the fintech team, working with startups and large firms across RegTech, payment, and crypto assets. He has prior experience as an open banking consultant for a fast-growing SaaS fintech in London, working with EMIs and Tier 1 banks delivering their digital transformation projects. Christian has recently contributed to the UK's regulated liability network discovery phase, exploring multi-asset atomic settlements through a shared ledger for financial market participants. Christian has extensive experience in business intelligence within technology, working with cloud agnostic global firms to deliver growth strategies and operational operational models with collective deals, sizes exceeding 7 figures. Christian holds a master's degree in science from University College London, with special focus on economics, policy, and effects on key value chains. Our last mentor for today, Omotayo Alero. Mr. Omotayo Alemero Abiode is the founder and lead consultant at My Digital Lawyer, where she uses her experience in intellectual property and entertainment law to educate and enlighten creatives and entrepreneurs on how to legalize and protect their brands and innovation. She has a master's degree in intellectual property law and policy and has completed several certifications in intellectual property with international organizations, including but not limited to the World Intellectual Property Organization, WIPO. Omotayo also widely known as My Digital Lawyer, regularly advises and represents a wide range of brands within and outside Nigeria on transactional commercial issues, including basic and technical legal issues surrounding intellectual property, media and entertainment, with about 10 years post-score experience and about 5 years active experience in being an IP lawyer and tutor. Omotayo likes to identify herself as a woman in entertainment and intellectual property because she constantly works with entrepreneurs and creative, and she uses her practical experience to teach intellectual property rights, thereby helping business owners and creative legalize and protect their brands, innovation, creative works effectively. Omotayo has an excellent reputation for constantly sharing great values with her audience online. She has been interviewed on quite a number of shows on international TV like Arise News and Xpeed Media in the United States, both digitally and in person respectively. She also has a YouTube channel, My Digital Lawyer, and if you're searching for her pages on YouTube, I think also on Instagram, My Digital Lawyer, where she posts legal content on IP, entertainment law, and related contents to help businesses and creators understand how to protect their intellectual property rights. She does this across all her social media networks, such as Instagram, Twitter, LinkedIn, Facebook, and TikTok, like I said earlier. Mr. Omotayo stands out for gender equality in the workspace by using her voice, especially on digital media, to communicate the need to embrace equity as well as to celebrate diversities, particularly in the creative community, so women can be given equal opportunity as their male counterparts in every sphere of work. Thank you very much for joining us. All our mentors, our 3 mentors for today, we hope the 3 of them can make it to the call. We look forward to learning from you on the topic for today, intellectual property registration, infringement, and enforcement. I will be giving the floor to our first mentor for today, Ms. Omotayo Alera. I can see her on the call. So kindly note that you have 20 minutes to give us your talk, introduce the topic, and also enlighten us on it. Do we still have Ms. Omotayo on the call?
I'm sorry, I thought I was not muted. Hi, good evening, everyone.
Good evening.
I'm not certain I can actually hear you clearly. I don't know if it's my audio, my speaker, or your audio.
I think it's mine. Maybe I'll just switch device.
Okay, I'll just turn on captions so I can probably read what you say as you speak. Okay. All right, welcome everyone. So I'll just thank you for having me once again, and I'll just like to share my screen quickly. Sorry, I was trying to fix my screen. All right, so we're speaking about IP registration, infringement, and enforcement. I'm not sure I got your slides. I requested for it, but I'll just quickly go through. I suppose you're going to share yours later in the course of this conversation. So quick one. This conversation is going to be brief, but I'd just like to go straight to the practical aspects while I teach you the theoretical aspects. Safeguarding your IP rights or your client's IP rights, since we're speaking to lawyers, it's essential for you to protect the creative ideas and innovative ideas of your client or of the creative that you will be working with, right? So basically, intellectual property has to do with the property of the mind. I like to say the property of the mind. That's a very, very simple term. So it's not the real property like what you can hold, not something tangible, but something that you can really hold on to, right? So it's the property. Can I have the AC on this? So it's the property of your own mindset, of your own creation. So in this particular session, I'd just like to address the registration of those rights. And then I'm going straight to the primary forms of intellectual property. I listed 4 of them here: copyright, trademarks, patent, and trade secrets. But I'd like to point you all to the fact that these 4 common types belong to 2 separate categories. This is not often said, but you just have it at the back of your mind. It may matter, it may not really matter. So copyright is on the one hand, while trademarks, patent, and trade secrets is on the other side, which those 3 form the industrial rights, while copyright belongs to a distinct right on its own. And copyright is the only intellectual property right that does not require registration. It's not mandatory for you to register your copyright because it exists from the moment it is being created. So let's say copyright is like the god of IP rights. That's what I like to call it. It's like it belongs, it exists by itself. You don't need to do too much to prove that. So on trademarks, on the other hand, okay, let me just speak briefly about trademarks. Trademarks are the right to your brand identity. So if you have something unique that separates you from every other competitor out there or someone else in your industry, right? Your trademark is what distinguishes you from every other person in that same in that same industry. So if you're in the music industry or if you're in the entertainment industry, it's not restricted to your name. But when you see a particular name or a particular I would like to use something different aside name. Okay, let me just stick to name. When you see a particular name, you can decide, okay, this name belongs to this artist or this name belongs to this brand because that is their identity. So the protection of that identity, because you don't want every other person to use same name or same catchphrase as yourself. For instance, let me use my digital lawyer, for example. That's my brand name, right? So if I'm going to have to protect it, because I don't want any other lawyer to use my digital lawyer, then it's trademark rights that I would have to do. But I'll go back to this when explaining registration of trademark rights with this particular example. Then patents. Patents happens to be, I like to say, the most difficult, not difficult, but you need to take extra steps when you're thinking of patents because it requires you to prove certain elements. The fact that it is the innovation or the invention is new, it's not obvious, it's new, or an improvement on an improvement on something existing already, an innovation. So you have something new, or you did something to improve on something that had existed. So the fact that you are improving on something or is something new, is an innovation or something you invented, is likely to be patented, but you also have to prove that it's not obvious. So non-obviousness, I've seen a number of people confuse the meaning of non-obviousness means someone in that same industry would ordinarily not be able to do this. So if you did something that is new, but every other person in your circle can easily fathom it, can easily discover what's behind what you did, then it has failed the test of non-obviousness. And these are things that will be considered at the point of registration. It's not just limited to Nigeria. It applies to other states. Then lastly, it has to be industrially applicable. So you see that the requirement for patenting is quite stringent. I would say it's quite strict, and all of these 3 points have to coexist. They have to happen concurrently, if that's the right grammatical term for that. Then trade secrets. I would like to call trade secrets as I would like to explain trade secrets as just like you say, secrets. It's your secret, but it's something that can be out there. So you just have to protect it. So popular example of trade secrets would be Coca-Cola, very, very popular. You see, you have the Pepsi Cola. We have this one's in Nigeria. People that drink Coke. Biggie, and some other brands. When you taste, or if you ever get to taste each and every of these brands, regardless of the fact that they're all made of cola, right? There's something that distinguishes them. I used to be a Coke addict before, but I know I don't do that anymore. So if I take Pepsi, I can't, even if my eyes are closed, I can tell this is Pepsi. If I take Coca-Cola, I can tell this is Coca-Cola. So there's a general ingredient, right, to make cola drinks, but there's the special ingredient that was used to make, I think I'm staying so long on this particular, I have limited time, right, Hussein? Okay, so trade secrets is the secret to your successful brand. So the best way to protect your trade secret is to sign a non-disclosure agreement with most of your staff. You can even protect that trade secret by keeping it confidential within a particular circle of people, because of course you can't use it for just yourself. You need to monetize your brand. So the few people that would have access to that need to sign some form of documents of confidentiality. Okay. IP rights registration quickly. This one, I speak about this every other day with clients, and I don't think we can exhaust this, but I'll try to be very brief. the registration process for all of these rights I have mentioned earlier, I'm focusing on Nigeria, because if you go international, it's quite different. So within Nigeria, if you want to register your copyright, or you want to, okay, let's start with copyright. If you want to register your copyright, the authority to go to is the NCC, the Nigerian Copyright Commission. And then you just ncc.gov.ng, that's the website. Is quite easy if you're familiar with it, and you do not need to register as an attorney. So you can register on behalf of your clients, a musical artist. You can have an account by yourself and register on behalf of other people. All right. I can share a link later. Maybe I'll send a link through your email, maybe through Hussein or Amina. So where I did an A to Z of copyright registration. This will help you if you ever have to register copyrights for your clients. The very, very easy step. Then the next is for your, the requirements for registering this copyright, right? Remember I mentioned earlier that you don't necessarily need to register your copyright because it's not mandatory. But if you have to, the requirement is basically the particulars of the author or owner. So practically, the NCC separates the author from the owner. Sometimes the author may not be the owner of the work. So it may be a company that owns the work, and then an author is different. So you have to get the details of the author, the details of the owner, particulars, basically, no need for ID cards. Then copy of the work has to be submitted to the NCC. That's it. Then the Ministry of Trade and Investment is, the Ministry of Trade and Investment is responsible for patents, designs, and trademarks. So if you want to register your trademark, you have to be, before you actually had to pay for accreditation, but now you don't have to do that. When I registered, I had to pay for accreditation like you do with the CAC, but now you don't have to pay for that. You have to register on the site as an agent. But before you do register as an agent, you should be familiar with how to go about this. Some things you need to tell your clients. You don't just take up a job on trademark registration if you're not certain if their mark is trademark worthy in the first place. And the way you find out is by checking if this, first of all, you conduct a search and check if this mark is not descriptive. If the mark is descriptive of what it does, then it's no longer a distinct mark. If the mark is insultive, so I've tried to register a mark one time and then the ministry rejected it because the mark was against public policy. It's the meaning in Yoruba was against, that's gossip. The meaning in Yoruba was against public policy. So you have to check some of these things. And the really, really interesting thing is you would think a search can be conducted online. You have to actually get to the Ministry of Trade to conduct a search. I don't know why it's not done online yet, but for other countries, you can do that online. And one other thing you need to inform your clients one other thing you may need to inform your client, or you need to know when you want to register a trademark, is the fact that the certification does not come in immediately. It comes in two separate forms. So the first thing you get is an acceptance letter before you get the final certificates. So that leads me to the timeline. But before I go to the timeline, I would like to speak about registration authorities briefly for other international registration authorities. The Madrid system, this is for about 130 countries, and Nigeria is not signatory to the Madrid system, just in case you get some international gig. And then the OAP, this is a French acronym for African Intellectual Property Organization. I can't pronounce the French word. Then we have the ARIPO, which is African Regional IP Organization. So some countries are signatory to some of these treaties. So what you need to do is, if you ever probably have an African, or if you have someone who wants to register their trademark, recall that IP rights are territorial in nature. I hope I'm not being too fast. I'm trying to finish up all of these slides in 20 minutes. So you have to remember that IP rights are territorial in nature. So you may want to save costs by sticking to some countries where your client is particular about. So if your client is particular about certain African countries, maybe the French-speaking countries or some other African countries, you can decide where to do a one-size-fits-all kind of registration, a registration that would apply to several other countries. The cost will be different, of course. Costs for registration in other countries are very, very, very high. Then copyright registration in Nigeria, from my experience, is relatively 2 months or a month. You may get it out as quick as a month. It's important that I state this here, that I always like to say law as it is and law as it ought to be. There's probably the guideline or the regulation that says when you register your copyright, you get it out within so period. But there's also the practical aspects where you have to, after doing your job, you have to follow up with someone, an insider, follow up with a staff member, follow up with someone so that your work you are certain that you get your job done. Of course, if you do not follow up, I don't think they would not release your certificate, but you want to get your client's job done in good time. Then patent rights certification, if you're able to pass the test, then every other thing should come out in a month, and it's just one certificate. Unlike trademark rights, I beg your pardon, copyright, you get one certificate, which is called a notification, and then the patent right, you get one certificate. But for the trademark right, when you register, the cost for registering this, official fees, 15,000 naira, search fee is like 2,500 naira. But in reality, I must say, because we're yet to talk about the practice of these things, in reality, you may end up spending much more than this to get your job done, if you know what I mean. So the entire process for the trademark registration, it should be like 18 months for your final certificate. So you would want to be amongst the lawyers that like to preach the real deal, right? You don't want to just say, okay, my trademark registration is just acceptance letter, because an acceptance letter, which is the first document that will be issued to you at the point of registration, is not the final certificate. I like to liken an acceptance letter to statement of results. I suppose we are graduates here, or even those that are still in school. When you finish your high school or university, and then the school issues you a testimonial or statement of results, that's like, use this one, hold body first, hold it first. The real deal is coming. So that's what acceptance letter is. So imagine you are holding body with acceptance letter, and you just abandon the entire process because you think this is okay. Do you actually hold on to just your testimonial or your statement of results without pursuing the final certificate? And then you can also tell your clients that when they get the acceptance letter, they can attach the TM to their name. So that's like notifying everyone that there's a trademark registration process ongoing. That's not the final bus stop. So you get your final certificate, which is after publication. There are 2 months 2 months period for opposition. 2 months period. So first thing first, search. You get an acceptance letter if your search is approved. You get an acceptance letter within 2 weeks, depending on how fast, or 2 months sometimes. Get your acceptance letter, then you wait for publication. There's a journal publication every year at the ministry. So after the journal publication, you wait for 2 months opposition. So any other person, maybe someone in your industry, can come and say, oh, this Mark Hussein exists already in so business, and we're opposing it. But if no one says, if no one's opposing it within that 2 months, then you're good to go. You can apply for your final certificate. So costs vary depending on mode of application. If you're applying by yourself directly, you save more costs. So it's good that you learn the entire process. I'll share another link. I'll share 2 links with you. One to my YouTube channel where I broke it down, A to Z of trademark registration. I went to my Instagram video where I did an explanation of how to register your copyright. It's descriptive. I shared my screen. So I think you would find it helpful if you've not registered copyright or trademark right before. Okay. Kindly let me know if I'm taking too much of your time so I can just run through this. I have like 2 other slides left. Importance of registration. While copyright registration is not mandatory, it is recommended to notify the public and to show proof of ownership. To show proof of ownership, especially in disputes. So you know how in law we say it's better to err on the side of surplus. So this means it's better to overdo. I like to bring it down so everybody understands. Better to overdo than to underdo, if there's any English like that. So now in copyright, you don't have to register. The law states that once you have your idea and is brought out in a form, your creative work, your artistic work is already out in a form, is expressed in a form, you're the original author or owner of that work, you don't need to register. But then there are instances every now and then, especially in the music industry, we see artists that say, oh, this guy JIIPCC stole my song, or I just say JIIPCC, that's an instance. This person stole my song, or this line, several times I get it in my DM that, oh, this particular song, my beats was stolen, blah, blah, blah. So sometimes it's good that once you get your creative work started, if you can't afford it as much as possible, get a copyright notification, do a copyright notification for your books too. I think that book one is even more common, right? So, and then so in the event that you're in court, it's good to show your certificates. It's helpful. Doesn't mean if you do not have that certificate, no one would give you audience, or you don't have a right, a local standard, you don't have a right to stand before the court, but it's good to just have it for backup as an extra point of proof. So you should know that the importance of this registration cannot be overemphasized. Registered IP provides legal protection, and these exclusive rights can be a valuable asset, potentially contributing to the creative worth. So of course, the rationale behind protection of IP, first of all, is also to be able to monetize your creativity, right? So if you are able to protect your rights exclusively to your own self, you're not just keeping it because you want to use it for yourself, of what uses it, but you're going to monetize. You may be able to license, you may be able to assign or transfer these rights. And when you're doing all of this, of course, money is flowing. There's an income that comes with it. You may get royalties, or you may get a buyout sum. You're able to monetize that particular creative work or that particular invention, depending on what it is. But if you don't have it protected, you are leaving your entire work open to thefts or infringers, to thieves rather, IP rights thieves. There's so many of them, especially online these days. And then several opportunities. Okay, I've mentioned these several opportunities for monetization. So it's important that you have, and especially if for trademark, I like to say, not just trademark, if your intellectual property is valuable to you, because if you don't take it seriously, if you don't rate your IP rights, somebody else can take it away from you, and then you'd be like, you'd actually regret it. So it's your job as a lawyer to help your clients monetize, exploit their IP rights in every way possible. But by all means, IP infringements. So, okay, IP infringements. I would like to just say infringement, just like every other right, you're infringing on someone's rights. So if
no, this one I rush.
When I was in my peak.
Okay, if a rights holder if you, as a rights holder, you're entitled to use that right. You're entitled to exploit that right. You're entitled to distribute that right and allow others to use. So when someone does any of these acts without your consent, without your express permission, they are infringing on your right. So these are acts that constitute infringement: use of a registered or a protected IP right without, excuse me, I beg your pardon, without consent of the rightful holder. So the best way to go about this is by identifying the violations. First thing I like to say, most times we say government should help people do this, government should help people do that. As a creative, as an inventor, you should notify your as a lawyer, rather, to creative, let your clients, the creative, know that first thing first is their duty to police or monitor their rights. So sometimes recently there was this person that was singing as this artist, what's his name? Well, I'm trying to remember his name, with pink hair. If someone can remember, let me know. So someone was
Ruga. His name is
Ruga in Kenya, and making so much money. Like, it was booked for several shows. So how did we get to know about this? The internet brought it out. But it's also your duty as the artist or as a creative, as an inventor, to police your work, to look out for, monitor your work. Some other times, maybe if you have collaborated with persons, maybe as a film producer, you collaborate with some other person and your film is being streamed, or maybe YouTube, if you're the YouTube, or maybe someone that makes skits, you have to do audits, get access to the analytics so that you are sure that, okay, my percentage of this money is coming to me, no one is cheating me. So audits, monitoring is your own duty. Then early detection is very, very useful. The earlier you do detect it, the better. Okay, someone on my slide. All right, early detection is useful to mitigate damages. So to mitigate the issues that may arise. So if the issues that will arise will be so grave, at the end of the day, it will be much more better, or it will be less costlier if you detected it on time. So it's still your own duty to detect. Then enforcement. So when there's this is like cause and effect. You have the infringement, then you have enforcement. Legal actions, enforcement basically will have to be through legal actions, first of all. And when we say legal actions, we're not saying the first thing is to go to court. The first thing is not a lawsuit. Most times you try to write a letter, maybe a letter to take down a particular, maybe, for instance, music on Spotify. You can write get a notification to YouTube, get a notification to Apple Music that someone is doing something, someone's infringing on your rights. You can do that. You can send a cease and desist letter, whether for copyright or trademark rights infringements. And then you can go to court, lawsuits, seek damages to compensate you for whatever loss that you may have or you are likely to encounter because of that infringement. ADRs, alternative dispute resolution, settlements. Oftentimes in the entertainment industry and every other related industry to intellectual property, we don't see our cases get to the Supreme Court. We start high courts or federal high courts. Federal high courts is the court we go to most times. Start with federal high courts, and then you see someone like, okay, you know what, Baba, let's just see how we can settle this thing out of court. I personally am not a huge fan of litigation. I don't like to go to court, but I'm curious. I'm looking forward to a time where one of these IP cases will get to the Supreme courts and make so we can get landmark decisions, like what happened in the case of Google and Oracle in the United States. There was a copyright issue between Google and Oracle, and when the United States Supreme Court made that made that, it was Supreme Court, made that decision. It was a strange decision. I can't really remember exactly what happened, but it changed the entire narrative of fair use. It gave a different description to fair use. And I'd like to mention fair use is a defense. It's a defense to IP rights infringement. So that means, for instance, like we are teaching right now, whatever materials we are using, even if you copied it from someone else's work and you do not even give them credit, the fact that we're using it for educational purposes, you're not monetizing what you have put out there, it can classify as fair use. Then for journalism and for educational purposes mostly, if you are not making profits from that particular work, even if you use someone's work, then that may classify as fair use, and that's a defense to infringement. So it's like saying you can copy my work, you may be able to copy my work, may be inspired to do my work, but if you're not making money off it, then we can let you go. That's what fair use is like in simple terms. So Antonpilla, if you look at the case, this common case, Antonpilla KG versus Manufacturing Processes Limited, that's a way to enforce the Antonpilla order. So it's an order that's given to allow you get into the premises to search for counterfeiting or infringing copies of work. Okay, I need to be fast about this. Major challenges. Okay, I would like to speak about Anne Njemanze and Zeb Ejiro, because this happened recently. As a lawyer, when someone brings, I said lawsuits and settling out of court. This particular case is a trademark case, and Anne Njemanze sued a character. She was supposed to be a character in a particular movie called Domitila. Maybe you have to look it up. And she sued the producer of the movie for using her trademark right, Domitila. Eventually, the lawyers to Zeb Ejiro had to apply to the Ministry of Trade to revoke Anne Njemanze's trademark right. So there's a likelihood of revocation of rights where the right was given maybe mistakenly. It was issued mistakenly. So their defense or their reason was Anne Njemanze actually applied for that trademark right maliciously. So if you get the entire gist, maybe I'll drop a link to this gist so you can appreciate what really happened. So it's your duty as a lawyer to weigh your options. Do you really have to go to court? Because she was the plaintiff, but eventually the tables turned around, and then the counterclaim is what they are still battling in court, and she has lost the trademark right. So she really may not succeed. She has a very, very slim chance of succeeding in a case instituted by her. Okay, major challenges faced. I'm wondering how this is on my slide though. Major challenges faced in reality: the territorial nature of IP, the fact that you have protected your IP rights in a particular country and you think you are absolutely protected, but you have failed to cover this protection, do a universal protection or do a worldwide protection. So like you see what luxury brands do, and this is also a financial related issue. Oftentimes, especially startups or upcoming creatives are not able to, if they can afford to even protect their rights within a particular jurisdiction, say Nigeria, for example, they may not be able to protect same rights in other countries, because recall I mentioned earlier, it's very, very expensive. We're talking thousands of USD, thousands of dollars, right? So you see luxury brands, well-known brands are able to do a universal protection, like Coca-Cola I mentioned earlier. Coca-Cola was definitely not manufactured in Nigeria, but you can't see any other brand, even a Nigerian brand, come up to say they want to use Coca-Cola. Their industrial design, the design of the bottle shape, the trade secrets, their trademarks, everything has been locked up universally. Another challenge is online protection of IP. I'd like to talk about commend the lawmakers for including digital protection of copyright. That's something new in the new Copyright Act. It wasn't there before. It was a major issue, but it's still an issue because so many things are going on in the internet, today, and it's almost really difficult for you to monitor. Yes, it's your duty as a creative or an inventor to monitor your work, but it's almost really difficult to be certain that no one online is infringing on your rights. Okay, so these are the practical challenges I think are faced. So conclusion, I'd like to say best practice for lawyers if you want to come into this industry, continuous education. In my profile, someone read that, okay, you read on my profile that I have a master's in intellectual property law, but I would like to say like 90% of what I know or 80% of what I know today, intellectual property, didn't even come from my master's. I've been reading by myself. So on your own, it's not so much of, it's technical, but it's not too technical for you not to read. If you're an autodidact, you're self-taught, you can read a lot to stay updated on evolving laws and industry developments. Then it's good to educate your clients because you can't expect that they know it. Also, if you have an artist, I keep saying artist, maybe because I'm usually with music artists. So if you have an artist or a film producer or a pharmacist, a chemist that's invented some drug or something, it's your duty to educate them, let them know the importance of IP management. And then cross-disciplinary collaboration. Collaborate with other lawyers, collaborate with other IP experts. You know, lawyers are not the only ones in intellectual property in this field. So there are scientists and there are other practitioners. Collaborate with them to ensure effective protection. Thank you for having me. Bye. Okay, not bye. Thank you. Let me stop sharing.
Thank you very much, Ms. Omotayo Alero, for that very wonderful session. It was very enlightening. Thank you for touching copyright, IP registration, trademark. Please remember to share the 2 links you wanted to share with us. Everyone on the call, I encourage you to subscribe to our mentor's YouTube page, follow her on IG. She's always dropping content on intellectual property, touching infringement and also putting in cases. This is something that all our mentees can always copy and can always follow the steps of our mentors' PowerPoint presentation by including case studies and live cases that are ongoing. Regarding the case you mentioned, I still have a question on that, but that will be asked during the question and answer session. While you started your presentation, Mr. Christian joined us. Thank you very much for joining, and I also recognize the presence of Mr. Okiogene Ubehe. Thank you very much for also joining us. So the floor is yours, Mr. Christian, and the topic for today is IP registration, infringement, and enforcement.
Hi, good afternoon.
Yeah, good afternoon, sir.
Okay, so I thank God I logged in to listen to the last speaker. And mine will be very brief because I don't know how it happened. I'm actually juggling 3 meetings at the same time, and I'm even on the road doing all those things. So she did a good job. She spoke about IP registration and all, so I wouldn't go into that. The only aspect I may just mention, I would speak more on enforcement very briefly. But for the IP registration part, the only part I would like to, say something. It's on opposition, right? As she mentioned, when you file a trademark, it goes through several processes, including publication in the journal, where parties are allowed 2 months to, not parties, like, the whole world is allowed 2 months to file an application for maybe opposing that trademark application. So for instance, somebody has a trademark, Coca-Cola, in class 32. So meanwhile, trademarks are registered in classes. We have 45 classes, so you must register your trademark in a specific class covering the goods or services that you render. So if, let's say there is an existing trademark Coca-Cola in class 32, and somebody files Lola Cola, and this is actually a live case in the same class 32. And, because the registry is not computerized and, because of some of the challenges we have there, that trademark finds its way past acceptance. Ordinarily, Section 13 of the Act says if there is an existing trademark in a class, no other similar trademark shall be registered in that class. So if I have Coca-Cola, no other person can be allowed to register Coca-Cola, Lola Cola, or anything resembling Coca-Cola in that same class, right? Unless the person, maybe like Coca-Cola now, decides to block all the other classes and decides to file a defensive trademark in the entire 45 classes. That way, they will block the entire classes and nobody will be, be allowed to register a mark in any of those classes. But so by virtue of Section 13, no similar trademark should even be accepted, for registration in that class again. But because of the way the registry is, they are not fully digitalized, so there are errors. Sometimes you can conduct a search. Let's say you want to register Coca-Cola and then you want to conduct a search to be sure that nobody else has similar trademark in that class. Ordinarily, what should come up? The search is supposed to disclose every mark that is similar to Coca-Cola in that class. But because our registry is not digitalized, you can conduct a search. Let's say in class 32, you're looking for Coca-Cola. Even you yourself that is conducting the search, maybe you even know that there is a Coca-Cola in that class. And then the registry will issue you a report and say there is no similar mark in that class. And then you go ahead to file a registration for Lola Cola because the registry said there is no similar mark. You now file a registration, and luckily for the person, it gets accepted and then gets published in the journal. Now, when it gets published in the journal, that publication is like the registry knows that there may be errors in acceptance and searches. That's why publication now, they are now giving the whole world a chance to come and oppose the mark if anybody believes that that mark is similar to an existing trademark. So when it is published, any person is entitled to file an application to oppose that mark. Now, why I want to highlight this is most practitioners, those that are not really IP practitioners, make the mistake of saying that you can only oppose a trademark where you have a prior existing registered mark. And this is very wrong. They will always cite Section 3 of the Trademarks Act that talks about infringement of trademarks and passing off and all that. It is wrong. Section 20 of the Trademarks Act that talks about opposition says any person is entitled to file an opposition. Simply state your grounds. There are other provisions in the Act like notification and the rest of them that makes provisions for other things. But for opposition, anybody is allowed to file an opposition. You must not be a registered owner of a prior existing mark or even a similar mark or anything. You can file a registration even if you don't have a registration in Nigeria. For instance, let's say we have McDonald's in the US and the proprietor does not have a registration in Nigeria, for instance, we are assuming. And they are not even in Nigeria. They are not doing any business in Nigeria, we are assuming. And then Mr. XYZ now goes on to file a trademark, the name McDonald's, and, wants to register it, let's say, in class 32, 33, or, any other classes relating to food. And then the McDonald's in US, they see the mark in the journal. They don't have a registered mark in Nigeria, but they have the right to come and oppose the mark, as long as they have valid grounds to oppose the registration of that mark. So normally, for that now, they can come and say that this guy registered this trademark in bad faith. and they will cite section 18 to say that this guy is not the owner of this trademark. We are the owners. We developed it, even though we've not registered it in Nigeria, but we developed it and we have been using it all over the world. It has a well-known status. We are entitled to common law and protection in passing off this and that and that and that and that. And it's possible that they can win. When you pick a copy of the compendium of trademarks rulings, of all the rulings, opposition rulings that the trademarks opposition protected, if you're able to prove that you are the owner of this mark and you have been using it, you have done so many things, you have been associated with this mark. So whether it's registered in Nigeria or not, we will still protect you. And these are the very few instances. We talk about territoriality, of course it applies. We talk about first to file in Nigeria, it applies, but there are always exceptions when it comes to practice. So that is the only aspect I wanted to point out under registration. Then we'll come to enforcement. Enforcement is the part I like to do, especially when it comes to anti-counterfeiting, right? I do a lot of brand protection for many of the multinational brands, right? So the last speaker mentioned something very important. As an IP rights owner in Nigeria, you are to police your rights. In fact, out of all the statutory IP rights, it's only copyright that the government can even help you to police and protect. Copyright Act has provisions for both the criminal aspect, civil. Even the NCC can do some administrative stuff. They can even do raids, seize pirated copies and destroy and all that and all that. But when it comes to trademarks, patents, designs, you have to police your rights yourself. You have to check out and see if anybody is infringing, you person, or you take any action that you are supposed to take to protect your interest or your rights, right? Now, there is actually no specific law that, makes provisions for when it comes to, we call it generally anti-counterfeiting, when it comes to protecting your IP right, especially when it comes to trademark, because that's the one that is being counterfeited a lot, where you see a lot of infringement. Infringements can come by way of somebody copying your trademark by using a similar mark. It can come by way of somebody using your exact mark on a similar product or even on the same product. It can come by way of outright faking. There is a product, let's say this product, and then somebody goes ahead to just go to the printer, take out this label, reprints it, places it on a similar bottle or the same bottle and package the same product. That one is outright fake and all that. It can come in so many ways. But as a brand owner, you have to police your rights first of all. You have to do investigations yourself or through your agent or through your attorney or through your... In fact, most of these big brands you see, GSK, Pfizer, all of them, some of them in Nigeria, they even have in-house anti-counterfeiting teams to show you how serious these things are. They have a team of probably investigators. Some of them will have like retired enforcement agents, like retired policemen or something working for them, investigate, always looking out for who is counterfeiting their product, who is faking their product. And then when you see any of these things or all of these things, right, because there is no specific law saying this is the way to go about it, it's a lawyer's ingenuity, an IP lawyer's ingenuity that will come into play on how you can enforce that right. Now, when you see that somebody is doing a counterfeit, a fake of your product, and you want to take action, you want to enforce, you first of all reason what's the nature of this product, so that you will even know the enforcement agency that you can engage. We have agencies that could help you when it comes to enforcement. For copyright, NCC is there, but for trademarks, FCCPC, that's the Federal Competition and Consumer Protection Commission, is there. NAFDAC is there. Standard Organization of Nigeria is there. The police, they are there as well. And you are at liberty to pick any of these guys depending on the nature of the product. So if it's a regulated products are cosmetics, detergents, water, food products, chemicals, all those products that NAFDAC regulates. you can choose to go with NAFDAC for enforcement. If it's a manufacturer, these finished products, sandals and maybe shoes or stuff like that, you can choose to go with Standard Organization of Nigeria. If it's any other product, generally, even the regulated products that NAFDAC can help you, you can choose to go with FCCPC. Anything that can cause damage or harm to consumers, you can choose to go with the FCCPC, you know, and then generally as well, you can choose to go with police. In fact, some of those other enforcement agencies, when they are doing their enforcement rates and action, they also go with the police. Their stuff. Sorry. So yeah. So when you've done your investigation and you've picked out, you know, the people or the guys you've seen that are doing the fake, sometimes these investigations are not as simple as it sounds, right? For you to get all this information, because some of these infringers are actually in a cartel. You can just see the finished products for people selling them on the streets, on the roads, or anywhere. But for you to trace the source, it's a ball game altogether, a different ball game, right? So if, for instance, you succeeded in getting the information and then you've been able to pinpoint the enforcement agency that will help you, two things. You can go by way of cease and desist letter directly to that person or to that company. You can choose to engage the enforcement agency to do a raid on that company, or you can choose to go to court where you can even get an anton-pillar order for you to invade the premises of that person or whoever and seize all the goods that they have and put it in the custody of the court pending the termination of the infringement suit, right? So these are the various actions you can, you know, choose to do. They are all there in the laws and the agencies are there. It's meant for you to activate the one that is most suitable for your circumstance. The problem will usually be cost. That's the problem most companies, in fact, most of these companies you see, they have special budgets for brand protection. And it's not a lean budget, it's not a small something, right? Because the cost can be very heavy. You're not even paying like official fees to police and all to help you, but at the end of the day, you would have spent a lot. And one of the costs associated is we have enforcement agencies, right? But of course, we know ourselves, this is Nigeria. And they are not statutorily, you know, meant to help you do all these things. So if you want to engage police or NAFDAC or any of those guys, for instance, to do a raid or something, if you wait for them to do it on their own, you have to wait forever. So sometimes you have to mobilize, you have to provide the vehicles that are needed, because you can't just go with a small car like this. You know, you have to go with a big bus, maybe a big bus conveying the officers and policemen. You have to go with a truck that they will use and pack all the products that they will seize. So you will get all those, you will even get loaders, you will even get police. So you do a lot of mobilization. You will spend millions in mobilizing all these things for you to conduct the raid. And that is why sometimes some companies will now, when they check the rate of infringement, if they feel it's not too rampant or that the cost outweighs, normally the benefit will always outweigh, but if they check that the cost is actually too much and they are not seeing an immediate benefit, they will choose to leave it. And then the fake keeps spreading, right? So one of the challenges I know is issue of cost, and then dealing with the enforcement agencies themselves. They are bureaucratic, by their bureaucratic nature, somebody may even lose interest in the whole thing. There are instances where you do an investigation and you're able to locate, that this is the store, or this is where these products, the fake products, are packed. By the time you finish all the bureaucratic process of writing petition, the police will get approval, they will do this one. If, for instance, you're going to a state, maybe 2 states, or the time they will do get approval from Commissioner of Police, you do approval from the local DPO, blah, 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 blah. And you get to we've had a similar experience. By the time you do those, by the time you get to the warehouse where you saw those products before, everything must have disappeared. So imagine wasting all those money, mobilizing, getting trucks, doing everything, only for you to get to the point and the goods have all disappeared because time have been wasted, in preparation, bureaucratic process. Then there are also other issues around corruption, leakages, leakage of information and all that. I won't go into all that aspect. But these are the things. And then, in fact, the law itself also does not really help because, like I mentioned, there is actually no specific law on that. There are countries that have specific laws on anti-counterfeiting that makes it easy. But there are countries that have laws that, provide checks from even customs. For example, some of these fake products too are even imported. There are countries that have laws that makes provisions that makes, gives customs the power to even block those products at the port of importation. Our laws, we have a provision in one of the subset legislation for the Customs Act that makes provision for pirated whatever, but we don't have what we call an official customs record now. That is the only way customs will be able to know how to block those products and because you can't be telling customs to seize fake Adidas, for example, where customs officers don't even know the difference between the fake and the original. They don't even know who owns the original and all that. So these are the many challenges, some of the many challenges associated with, enforcement. And then finally, when you even come to court aspect itself, the cost of litigation, the time it will take. I know of a particular enforcement matter in court that started in 2018 until today. This is 2023. The hearing has not even started. So they are still on preliminaries. Sometimes you go to court, you not see, sometimes this and that, since 2018 till now, 5 years, and the hearing in the matter has not even started. The witness have not even been put on stand. So these are the various challenges that brand owners, when they face, sometimes some of them will lose interest in enforcement and, fake products will continue flying around. So I will stop here so that I can be able to, join my next meeting. Thank you.
Thank you very much, Mr. Christian. But before you go for your next meeting, I think we'll just encourage our mentees to ask questions if they have any question on your session before you go. We are still expecting to take our mentees' PowerPoint presentation and also ask other questions to our other mentor. If anyone has any question before Mr. Christian leaves, please raise your hand so that I'll call on you to ask your question. Okay, while we are waiting for our mentees to ask their question, I have just one question for you. With regards to especially the enforcement of IP rights in Nigeria that you mentioned and how corrupt the system is, what do you think is the way forward? What can we do to help improve the way we enforce our IP rights in Nigeria?
So obviously it will start with legislation itself. Hope you can hear me.
Yes,
so it
sir.
will start with the legislation. There are things that have to be put in place. For instance, I mentioned countries that have what we call customs recorders, that will make it possible for brand owners to be able to register their IP rights, especially trademarks, with custom officers, so that custom officers can easily trace fits, differentiate between counterfeit and original and block all those things, right? And then we need to have that will from, you use the word corrupt, and indeed the entire process is corrupt. You'll be surprised that sometimes you engage even the police to help you with raid or something, and then they will be the ones to leak the information and allow the guys to disappear with all those things. So you find out that the will is not even there. Enforcement agencies are yet to really appreciate the essence of what they are meant to do in relation to IP rights. Most people don't even care about all this infringement, when we talk about infringements and all of them, most people don't even care. They don't know what it is. They feel it's not something that affects them. But indeed, it affects everybody, right? I could give you a simple instance. I was in court one day where two lawyers were discussing about the death of a lady and what killed her. She had, I think they said she had cancer or something, which was detected quite early, that would have been managed with drugs. Unknowingly, she has been getting the drugs, exorbitant prices, but she has been getting the fake. So in her mind, she's taking the drugs, not knowing that she has been taking just chalk, and she's dying slowly, right? So, and despite all these things, people still don't feel the need. They still don't understand what the whole IP infringement thing is all about. They think it's, you know, it's an abstract thing, but it has a way of affecting everybody, right? Today, some of you may see some actors or producers, movie producers, or even music producers, and say, oh, these guys, they're not even rich, or they can't even take care of themselves, this and that, upon all the films they've been acting, this. And you don't know that it is the little things that we do sometimes that even contribute to this. For instance, a producer can fund a movie production and spend 100 million on it. The movie gets released today, and the illegal copies are circulated everywhere. You go on Net Niger, you download pirated copies and all, thereby cutting
They've
the
taken down
revenue.
Net Niger. They've taken down the site.
They've not taken down Net Niger. I'm actually the one handling that case. I'm handling that case against Net Niger at NCC. Okay. From what I observed in that case, let me not even preempt the whole thing. They purposely ran away because I was using their neck. So they did that thing to run away because I'm tracking them all over. And I could see that even though they've announced that they have shut down their websites, their Telegram is still active and they're still shooting out movies. So when you go on all these sites, not only Net Niger, there are lots of them. Niger,
yes, sir, there are lots. You know, Nigerians, we always have a way around.
Exactly. So when we do all these things, you know, you find out that I'm working with the American Motion Pictures Association now, and I'm seeing a lot of things. When you look at statistics for producing movies and how pirated all these pirated sites, you know, make them not to be able to even get the revenue that they even spent, the expenses, the cost spent in the production, not even to talk of the profit. You see how bad and terrible these things are, right? I could remember when Coming to America 2 was released. The same day it was released, the same time, within the same hour, that movie was already on Net Niger. Something that some people are meant to subscribe to Amazon Prime to watch or go to cinema to watch, pay, you know, some money so that the producers could have something. It's already there on Net Niger. You simply use maybe 3.5 gig, or not even up to that, maybe 300 MB. You download it and you watch it at home. You don't know that by doing that, you are killing the legitimate interest of somebody else. You're rendering someone, pushing somebody into poverty. So that will, that awareness is also a way, you know, to cover these challenges. Thank you.
All right, thank you very much, Mr. Christian. I wish we could have you till the end of the call because I know that some of our mentees will still have more questions, but thank you anyways. Anybody that has any question for Mr. Christian, you can send it to the Jiipcc email. I will forward it to him so that we'll get your response. Thank you very much once again, sir, for coming and have a lovely day. I'll be calling on our mentees to make their PowerPoint presentation quickly. You have 15 minutes each. Do we have two groups, Mr. Dennis? All right, I know there is always a group one. So group one presenter for the week, kindly raise your hand. Sorry, kindly unmute yourself, share your screen and start your PowerPoint presentation.
We have two groups.
What did you say?
I said we have two groups, not one group.
Okay. two groups. All right, group one, it's over to you now. The presenter is not ready. I believe we have a backup presenter. So our backup presenter can just jump in immediately. Let's take note of time. All right, we don't have all day. So group two, if group two is ready, we can take group two's presentation.
Okay, I'm the presenter for group one. Good evening. I'm sorry, my network was not good. I'm very sorry. So I'm going to start my presentation now. I'll share my screen.
I'm backup presenter.
I'm the presenter.
Okay. Kindly share your screen and start immediately.
Okay. I'm coming. I'm trying to share my screen. I don't really. Okay. So, I'm sorry, I checked the file.
We can't see your screen. We're only seeing your Zoom screen.
Okay, I'm coming. I'm sorry for the delay. I'm very sorry.
Okay, while you are trying to share your screen, you can just start your presentation. Let me see if I can help.
Okay. So the topic of the week is IP registration, national, regional, international registration. First, the definition of international property is the creation of the mind, such as inventions, literary and artistic works, design, symbols. So basically, anything that is invented is an international intellectual property. We've treated the definition in the past weeks. So the first to look at is what is a patent law, and a patent is an exclusive right for an invention, and it provides the patent owner with the right to decide how the invention can be used by others. So the next thing to go to is copyright law. Copyright is usually known as author's rights, and it's used to describe what rights the creator has over his work. The things that can be protected using copyright are literary works, computer programs, films, musical compositions and choreography, and also artistic works such as drawing and paintings. Copyright protection, it's not only expressions that it actually extends to whatever you express from your mind. It's as the first mentor said, it is the property of the mind. So after copyright, there's also trademark, and trademark is what distinguishes one brand from another brand. It can be the logo, it can be the name, it can be the symbol, and all of that. And trade secrets are confidential information that can only be sold or licensed to another person, and is not for the general consumption of the public. For trade to qualify as a trade secret, the information has to be commercially valuable, not just anything can be a trade secret. It has to be valuable. It has to only be known to a limited number of persons. You can't say it's a trade secret and everybody knows the secret already. And it has to be reasonable also. So to register your intellectual property in Nigeria, they said there are three main laws. There are Copyright Act, Patents and Designs Act, and Trademark Act. And it's the Nigerian Copyright Commission that is recognized that is in charge of copyright protection. The Trademark, Patent and Design Registry is in charge of trademark and patent protection. And the Nigerian Copyright Society is just management for copyright related issues. So to register your IP, the first step is to identify the type of IPs. Better to get legal advice when you want to identify the type of IP. So it's not be like as if you now go and register a different IP for a different IP that for a different purpose. So after identifying it, you conduct a search to make sure that another person has not yet registered that IP. Maybe it's a trademark or it's a patent. Make sure that it's only you that have done something like that. Then you would gather all your necessary documents like application form, proof of ownership, and all of that. Then after gathering your documents, you file the application. You submit it to the necessary organizations, necessary agency. If it's the Nigerian Copyright Commission or the Trademark, Patent and Design Registry, you would submit it, file the application. After filing it, you are going to pay the required fees because obviously you can't get it done without paying the fees. And after paying the fees, the registry or the organization will examine your work and to make sure that this copyright that you want, this international property that you want to register, it is valid. Then after that, it will be published. After it has been accepted, it will be published in the journal, and it's until it is approved from the journal that it can be registered. Then the laws of copyright in Nigeria, that's the Copyright Act 2004. The first one is that the Copyright Act, it governs intellectual property rights related to literary, artistic, and musical works. It provides protection for authors and creators of original works, giving them rights to reproduce, distribute, and display their creations. And in Nigeria, copyright protection lasts for 90 years. Okay, the lifetime of the author plus 90 years. So for instance, if the author dies, he has 90 years extra before the copyright expires. So for trademark, it's the Trademark Laws of the Federation of Nigeria 2004 also. It deals with protection of trademark. It allows individuals to register their trademark to protect their brand identity. And it is actually protected for just 7 years, but you can actually renew the trademark. Unlike copyright that is for a lifetime, but trademark, it has to be renewed every 7 years. So if your trademark has expired and you do not renew it, another person can come and take over. The third one is the Patents and Design Act, also 2004. It focuses on the protection of inventions and innovations. It allows inventors to obtain exclusive rights to their invention for a certain period, and in Nigeria it's 20 years. And it encourages and protects the rights of inventors. All these laws are necessary. So if you cannot actually fight for a copyright, a patent, or whatever without knowing the laws behind it. So the requirements for different type of IP registration in Nigeria for copyrights, according to Section 87 of the Copyright Act, the first requirement is to acquire the registration form from the NCC. After acquiring, maybe you get it. After you get the registration form, you have to fill it. Then after filling it, you submit 2 copies to NCC. Then you pay the fees prescribed by the commission. After the confirmation of receipt, the commission will approve your copyright. For the trademark, the first thing to do is to conduct a trademark search. Make sure that your desired trademark is not already registered and is not already used by someone else. After confirming that, you now fill out the application form just as you fill the application form in the copyright. Then you submit a power of attorney signed by the applicant. Probably a lawyer or an attorney would sign your work. And then priority claim. I think priority claim is like if it is from another country, you can actually claim priority based on that earlier. Then after priority claim, you pay your fees, and the trademark will examine your work to make sure it completes all requirements. If there are no objections, it will be accepted for registration. Then publication. That publication stage it can still be refuted if another brand, maybe another brand that is outside Nigeria, realizes that, oh, their brand name is published, or something very, very similar to another brand is published, they can refute it. And if they oppose it, you have to take it back. But if nobody opposes it, then your trademark is successful. So for patents, I think patents is a little bit more complicated than the other kinds of intellectual property. So the first thing is that it has to meet some criteria. First thing is that it has to be novel, it has to be new. It's not like as if you now produce something that someone has already produced in the past and think that it's a patent, you can patent that production or that innovation. It has to be entirely new. So, and like, it's not like only Nigeria or any part of the world, nobody must have that, it must have not been produced by anybody in the world before. Then after that, the inventive step, it must not be obvious to a person skilled in the art. That it must not be obvious. Like another person cannot just easily come up with the design. It has to be something that is technical and, let's say, complicated. Because if it is obvious, anybody can just think of it and do it, and you just decide that you want to patent something that everybody else can do. So after that is the industrial applicability. It must be deployed in an industry, and it's considered an improvement on a patented invention. So after that is the patent application must include a detailed description. You must describe whatever you are patenting. You must describe your innovation so that they will understand that, oh, this work, this innovation is actually a very, very good one. Then it must include the claims, is similar to the description, and the power of attorneys. Also, the agent, maybe the agent or the lawyer that is conducting the registration on behalf of the applicant. So the primary legislation that governs the registration of patents is the Patent and Design Act, the Commercial Law Department of the Federal Ministry of Industry. So the procedure for registration of a patent, after you've ensured that your patent has already fulfilled all the criteria I've mentioned, you have to now start the registration. First thing is that you search to determine if the invention is new and not obvious. So I think you can do the search, you can conduct the search at the Nigerian Patent and Trademark Registry. It's better with the assistance of an attorney, a lawyer, or a patent agent. After the search, you prepare the application. You must fill the documents. Then the applicant must have an address within Nigeria, a signed power of attorney, a specification including a claim or claims in duplicates, like you can photocopy it. If it's applicable, if you can draw it, and a declaration by the true inventor. If you are the inventor, you declare that, okay, this is me, I am the inventor of this work. So if someone wants to claim a foreign priority, if like maybe it has been made in another country and something similar is made in Nigeria, the foreign application will take priority over the one in Nigeria, because the foreign person has already like registered before the Nigerian did it. So the procedures, okay, after, and then you file the application. Application can be filed electronically or in a hard copy at the Nigerian Patent and Trademark Registry. And the application must be accompanied by the filing fee. And the filing fee covers only one patent. You can't pay for two, you can pay for two, but it's one fee per patent. You can't say, okay, because I've paid for this one, the fee will cover another one. It doesn't work that way. So then once the application is filled, it is examined to make sure that, okay, this application, this patent is actually legitimate and it ticks all the boxes. And if there's no opposition, the patents will be granted. So trade secrets. In Nigeria, trade secrets are protected under common law and there is no specific registration system. dedicated to trade secrets, but there are legal measures in place. So the legal like, what is a trade secret? I've said it before, it's like a confidential business information that provides an enterprise with a competitive edge. Like the most popular example, Coca-Cola. I think KFC, so nobody knows their chicken recipe is a secret, is their trade secret. So that's like the example of trade secrets. So the first protection is the common law. The common law principles is it actually protects trade secret, and courts can actually enforce the protections in case of breach of confidence. For instance, you have a worker who actually worked with you, maybe some KFC hired someone to work with them, and maybe the person stopped working and the person went to review the recipe to another person. They can actually charge the person for a common law crime to the person, and you can sue the person to court because of the breach of trade secret. Then the non-disclosure agreement. If you have employees, contractors, businesses, investors, whatever, they have to sign a non-disclosure agreement. That agreement legally binds the parties involved and outline the obligations regarding the confidentiality of the information. Then employment contracts and company policies. You have to like tell this person that, okay, before you start working with us, you have to sign, like it has to be in the contract and it has to be in the policy. So it won't be like as if you didn't actually mention to this person before that this was a secret. And the person might have actually honestly not known that it was a trade secret. But once it has actually been signed and it has actually been included in the contract, the employee will definitely know that it's a trade secret. And if the person breaches that secret, then it is a crime or an offense. So steps to protect trade secrets. First one is identification. You identify the trade secrets. Then you restrict access. You can't have a trade secret and it's like now KFC. You can't have the recipe and it's every worker that knows the recipe. As long as you are cooking, you're not making the meal. You don't have to know the recipe. It's not every person that needs to know it. You just restrict the access to the 5 people that are in charge. Then you train these people. You tell these people that, oh, don't go and be mentioning it everywhere and all of that. Then physical and digital security, you make sure there's security measures to protect the trade information from unauthorized access. Then the non-disclosure agreement, that's the NDAs that will be signed. And then the periodic review, you review your security measures and confidentiality policies frequently. Although there is no specific registry for trade secrets in Nigeria, the protection of trade secrets relies on the proactive effort of businesses or brands to work on it. You can't just have a secret and not work on it, most especially for the fact that there is no specific registry for trade secrets. So if you want to protect your trade secret, you have to protect that. If you still make all that protections and somebody breaches your secret, you can actually then take legal actions. And it's compulsory, like almost everything is necessary to take legal advice. So then the relevant authorities for all types of IP in Nigeria, several laws have a bearing on the administration. So the major acts are the Copyright Act, the Patent and Design Act, and the Trademark Act. The Copyright Act provides protection for literary, musical, artistic, any creative arts or authorship, and it grants the author rights to do whatever he wants to the book without an external involvement, and make sure that another person does not come and take over whatever the author has already produced. So the Copyright Act cap 68 Laws of Operation of Nigeria, Section 1, Subsection 1 provides for the works protected by copyright, literary works, literary works like books, musical works like music, artistic works like paintings, cinematographic films like movies, sound recording like maybe podcasts or beats. It doesn't have to be like a complete music as long as it's recorded, and then broadcast, maybe news or information. The relevant authority, okay, then the Trademark Act provides for the registration and protection of trademark. Section 67 of Trademark Act 2004 defines that any sign, design, or expression that identifies and distinguishes the goods or services of a particular trader or service provider. So the Act sets out the requirements for registering a trademark and the rights and the obligation of trademark owners. So that is the major thing of the Act. You can go and check it out. So distinctiveness is critical. It must be distinctive. You can't just make a popular, maybe something that everybody draws, maybe a square that is not this. If you see this square anywhere, you can't think to it that it is a trademark. So it has to be distinct, and or something that somebody has done before. No, it must be distinct. It must be unique. It must be all those things. Like it must be distinguished from one another. So that distinctiveness is what makes a trademark a trademark. If it's not distinctive, it cannot be a trademark. So for patents is inventions like machines, devices, plants, not regular plants, but plants that you actually, I don't really know about it, but plants that is not just like maybe you just plant beans or something, like all those artificial plants that you do, that's all these horticulturists do. So the Patent and Design Act, it outlines conditions for the intervention to be deemed patentable. So it must be new, it must be the result of an inventive step, and it must be capable of industrial application. So in international level, it is actually complex. You can't just register something in Nigeria and think that another person in another country cannot have it. For instance, maybe you have a brand name and that person abroad has the same brand name. So, but for international registration, there are systems like the Patents Cooperation Treaty. It helps applicants seek patent protection internationally. The Madrid system for the international registration of marks offers a solution for registering and managing trademarks. But each country has its own rules and processes. So even if you do all those things, it can still be shaken if you don't actually go to this country and register your patents or your international property. So, but for literary work, copyright protection is key. The US Copyright Office is one of the most authoritative international copyright treaties. So it's better if you want international copyright, better to go to the US because it is authoritative. But each country has its own IP laws, and the United States Patent and Trademark Office oversees patent and trademark, while the US Copyright Office oversees copyright. European Union manage trademark and designs, and for patents, there's European Patent Office, Nigeria, as I mentioned, Nigerian Copyright Commission. So Nigerian law, how does it relate to others? Of course, Nigeria is part of some international agreements. It still makes it authoritative in a way, although there can be some differences and all of that. Then the Paris Convention is a treaty that Nigeria is part of. It applies to international industrial property like patents and trademark, and it includes the right of priority, which allows you to file for protection in the other state parties within a certain period. And it to be considered as if you filed on the same day as your initial filing. But the duration of copyright protection can range from 50 to 70 years after the author's death, depending on the country. Like Nigeria, I mentioned that is 70 years for copyrights. I think so. Yes, 70 years for copyrights. And the process for registering and enforcing patents and treaties can vary. And that's the end of the presentation. I hope everybody understood what I presented. Thank you for listening.
Thank you very much, Zainab Adesina, for that wonderful presentation on behalf of your group, Group 1. Well done. Very, very comprehensive research done there. To all of us that have that slides, kindly go back to read through the slides. It's very rich and very, very packed with information on the topic. I'll leave other comments to our mentor when she comes in to comment. But before we call on the Group 2 presenter, let's quickly turn on our videos, smile for the camera for 60 seconds while I try to take pictures of our beautiful faces for our social media posts. Thank you very much. I can't see our videos yet. Please, everyone is encouraged to turn on their videos. Thank you, thank you. Thank you very much. We have a very low. Most of our mentees are not turning on their videos. Let's see your beautiful and handsome faces, please. Akinde, sorry, Chiamaka, Timothy, Goblaha, Victoria Popola, Amo Abimbola, Joy, Mary Oza. Let's see your videos on Fadira. Sorry, I didn't pronounce that name. Fasusi, sorry. Let's see your videos on. Thank you very much as you do so. All right, let's just say some of our mentees are shy. I don't know why. So that's why they are not turning on their videos. All right, we'll be taking Group 2's presentation quickly before our mentor jumps in with taking comments on the presentation and also answering all our questions before we end the session for today. So Group 2 presenter, I hope you're ready.
Yes, I'm ready.
All right, you can start.
I want to try to share my screen. So can you all see my screen?
Yes, we can see your screen.
Okay. Good day, everyone. My name is Akinde Precious, and I'm here to guide you through the presentation for Group 2.
Please, can you rotate the screen so that we can see it clearly? Thank you.
Okay. Can you see it like this? Is it okay now?
Yes.
Much better.
Okay, I'll start now. Good day, everyone. My name is Akinde Precious, and I'm here to guide you through the presentation for Group 2. Our focus today is on intellectual property infringement and enforcement. Now, let me introduce you through the key areas to be delving into to enhance better understanding of our topic. First, I'll be explaining the meaning of intellectual property infringement, types of intellectual property infringement, cases under them. Majorly, we're going to be highlighting them because of time. Intellectual property enforcement, ways in which intellectual property can be enforced, cases on intellectual property infringement and enforcement. So, enjoy. First, what is intellectual property infringement? Intellectual property infringement refers to the violation of rights associated with intellectual property. A clear example of this violation is when individuals or entities utilize a third party's image, trademarks, logos, design, or other intellectual property elements without obtaining the necessary permission from the rightful owners. The term IPR infringement pertains to the unauthorized utilization, replication, or sales of material or products that can hold legally protected intellectual property status. So let's note that before there can be an intellectual property infringement, there must first have been an intellectual property already in existence. Then the infringement comes in play when someone else that is not the owner of the intellectual property and has no legal authorization of the IP utilizes, replicate, or claim ownership. So basically, in a layman's term, an intellectual property infringement is when someone uses, copies, or reproduces someone else's intellectual property which violates their rights. So when intellectual property are infringed upon, the rightful owner generally has the legal prerogative to initiate legal action against the offending party. A case study on this instance, for instance, a few years back, Disney sent cease and desist letters to daycare centers that decorated their walls with images of Disney iconic characters, such as Mickey Mouse and Goofy. So, like, the main essence is to stop those people that use their registered trademark to stop infringing on their rights. So just like how Disney did, every other person that own an intellectual property and notices any form of violation in their right have the legal right to initiate any legal action. Since I've established what intellectual property infringement is all about, let's go on to the second segment, the types of intellectual property infringement. It is a trade law that the main types of intellectual property rights can be granted are trademark, copyright, patent, trade secrets, and industrial designs. Hence, the infringement of these rights would be referred to as copyright infringement, patent infringement, trademark infringement, trade secret infringement, and industrial design infringement. So let's go on to understanding what copyright infringement is all about. So in summary, copyright infringement means using someone else's creative work, like music, movies, or books, without their permission when you are supposed to ask for permission. That's it. This breaks the rule that give the creator right, like the right to copy, share, or make changes to their work. Copyright infringement disputes copyright infringement are always resolved through direct negotiation, a notice takedown process, or litigation in civil court. Now let's look at some copyright infringement cases to provide a more practical understanding of how copyright can be infringed. The first case is the case of downfall drivers versus techno downfall drivers. So basically, in this case, downfall drivers accuse techno of using their song Polongo without permission in his 2018 single called Jogodo. Yeah, that's it. They met in Lagos to settle the issue, and Techno shared a photo of their reconciliation on Instagram. So basically, we heard that Techno compensated the downfall drivers 2 million because apparently Techno used their song Polongo without permission. We can also see an instance of copyright infringement in the case of Blackface versus Two-Face. The Blackface and Two-Face dispute in Nigeria music, the Blackface and Two-Face dispute in the Nigerian music industry centers around accusation of copyright infringement. So Blackface claimed that the ownership of the song's African Queen and let somebody love you, accusing Two-Face for infringement in 2016. So they settled out at the Ikeja Court's Alternative Dispute Resolution Center. This agreement involved Blackface stopping accusation of plagiarism and Two-Face agreeing to provide Blackface with the rightful royalties from the song. Okay, that's not important. So basically, in these two cases, we were able to draw out examples of copyright infringement, and the people that their rights were infringed, they were compensated. So let's move on to understanding what patent infringement is all about. So basically, patent is a legal right that stops others from using or selling an invention for a certain time. So patent infringement is a violation of a patent owner's right with respect to some invention. So literally, a patent infringement is when someone uses, makes, or sells the same thing as a patented invention without permission from the owner. So permission can be given through a license. If there is infringement, the patent holder can ask for damages, an injunction, or to cease or destroy the infringing items. That's all about understanding what patent infringement is all about. So let's go on to see some cases that will make us understand patent infringement in a more practical sense, but will not be explaining because of time. But we can see the case of Apple versus Samsung and the case of Litton System versus Honeywell. As I said, I won't be explaining because of limited time, but the two cases are instances of patent infringement. Sorry. Let's go on to trademark infringement. Trademark infringement is a violation of exclusive rights attached to a trademark without the authorization of the trademark owner or licenses, provided by the authorization, provided that the authorization was within the scope of the license. That is, trademark infringement is when someone uses a trademark without the owner's permission, basically. Infringement may occur when one party, the infringer, uses a trademark which is identical or confusingly similar to a trademark owned by another party. So like when someone uses a trademark that is identical to another trademark, and that trademark that be registered, that is an instance of trademark violation. So the second trademark infringement, that's like a primary infringement. Secondary infringement involves using a sign that is so similar to a registered trademark, and the product or services are so alike that it could cause confusion or association between the sign and the trademark without the trademark owner's consent. So in both primary and secondary infringement, creating confusion is a key factor. So let's go to the third type. The third type concerns well-known marks that are protected against the use of a mark that takes unfair advantage of or is detrimental to the distinctive character or the repute of the trademark. The term dilution is used as a shorthand way to refer to this kind of infringement. So let's go on to the cases under trademark infringement. But I will just be highlighting them because I don't want to waste too much of time explaining them. We can see the case of Louis Vuitton versus Louis Vuitton Deck and the case of Red Bull versus Big On. These two cases revolve around trademark infringement, with the court ruling in favor of the trademark holders and ordering penalties for the infringing parties. Now, let's go on to trade secret infringement. Now, trade secret infringement in summary is, okay, trade secrets are confidential information that can be sold or licensed. So trade secret infringement, also known as inappropriation. Trade secret infringement happens when someone wrongfully acquires, discloses, or uses this secret without permission, even if it's not intentional. So improper methods like breaking non-disclosure agreement, industrial espionage, breaching confidence, contract violation, theft, fraud, or bribery can lead to trade secret theft. In the digital world, this is called cyber theft. We can see an example of infringing a trade secret in the case of Appian Corporation versus Mega System. And also because of time, I won't be explaining the case, but the key points here are the unauthorized sharing of trade secrets, breach of non-disclosure agreements, and the resulting legal consequences for Pega systems. Now let's move to industrial design infringement. Industrial design involves designing products and services for functionality or manufacturability. Industrial design infringement varies by jurisdiction and is still evolving. Infringement occurs when someone uses a registered design for sale or exposure without permission. In Nigeria, the legal framework for this is the Patent and Design Act. So let's go on to a case that we can use to relate and understand what industrial design infringement is all about. So in an infringement case of industrial design is the case of Piaggio versus Jiipcc. The plaintiff claimed that Jiipcc, a company in Vietnam, used his design without his permission. And that case was seen in January 3rd, 2014 between BlackBerry versus Typo Products for design infringement of their popular quarter keyboard. Pardon my pronunciation. Now let's move to the second segment of the presentation, intellectual property enforcement. And I'm going to be scanning through because of our time. Intellectual property enforcement is the process of safeguarding IP right through legal action, administrative procedures, and public awareness. IP rights cover works like inventions, acts, designs, and commercial symbols. They are granted by law to promote innovation and creativity. IP enforcement is vital as it ensures creators are rewarded for their works, enables businesses to invest in research without self-concerns, and safeguards customers for counterfeit and low quality goods. Let's move on to the ways in which intellectual property can be enforced. So protecting intellectual property, especially in technical areas like industrial design and computer algorithm, can be complex. It often involves a combination of copyright, patent, and trademark. Intellectual property encompasses original ideas, designs, invention, and creative works. In the digital age, safeguarding these assets from infringers and copycats is crucial to enhance accessibility and distribution of information. Now, why is IP enforcement important? Enforcing IP rights can improve product-related health and safety, foster growth of economic industries, foster creativity, create incentive for investment, fulfill international treaty obligations. Now let's move on to the 5 ways to protect your intellectual property. First, register copyrights, trademarks, and patents. Registering copyrights, trademarks, and patents is crucial for protecting intellectual property. Copyright safeguards various creative works with protection lasting for many years, while trademark protects symbols and identities that help businesses connect with customers. Patents grant legal protection, excluding others from making and distributing your invention from 15 to 20 years after filing. So this registration is essential to secure exclusive rights and prevent unauthorized use or replication. So let's go to the next one. Number 2, you must take your time to clearly understand the difference between copyright, trademarks, and patents so that you can make the right decision. Because understanding will make you know the kind of protection you need for the kind of business you're starting. So you need to take your time to understand them. If you're planning to start a business with your IP, you can further protect your interest and identity by registering the business, product, or domain name associated with it. It will also help to secure these names, even if you are just in the planning stage of forming your business, before others could come up with a similar idea and cause some confusion. So let's go to the next one. I'm trying to rush because I don't want to go past the required time. Create confidentiality, non-disclosure, or licensing contracts for employees or partners. So I think that's where trade secret comes in play. Sometimes there is crucial information about your business that you should protect from leaking in public. For instance, you are developing a video game, but you don't want the details to come out before it's ready to launch. Just it should be prudent to ask the game developer and other people working for you who have knowledge or access to information or trade secret to sign a confidentiality agreement to ensure IP protection. So that your idea will not come to the public before you can guard your idea by signing contract like non-disclosure contract and creating confidentiality. Like for example, we have KFC bar and Coca-Cola. Nobody really know that key ingredient like that because there's this kind of non-disclosure with their employers. Licensing, on the other hand, grants a third-party partner access to your product for their use, branding, or distribution. Disney, for instance, gives licenses to toy makers and distributors for its popular merchandise. However, the licensor defines the parameter of the use of its IP, which may include the quality of the product or toys as well as distribution process. Since there are plenty of grounds to cover with licensing, it is important to consult with lawyers to ensure that all aspects of protecting the IP are established in licensing agreements. So let's go on to the next one, which is implement security measures. Nearly all businesses are conducted today using in technology or the internet. There is an upside to this because technology may fuel the growth, dynamics, and success of an operation. So it's very important to implement security measures because there are also downsides to using technology to conduct businesses, especially when your company's IP is integratedly connected online or stored in a system that may be vulnerable to hacking or file corruption. So there's a need to implement robust security measures within the IT framework of the company. This may include setting up protection, password protection for all computer network, encrypting data, especially since files are shared within the computer IT, virtual private network, VPN access. Okay. And that one is establishing Wi-Fi protection access. And the last one is invest in reliable software tools to use for storing and distributing files regardless of the size of your business, or opt for an online digital asset management solution. Invest in reliable software tools to use for storing and distributing files regardless of the size of the business, or opt for an online digital asset management solution. Now, the fifth one, avoid joint ownership. Intellectual property may be developed and created by more than one person, as in the case of a company that has its research and development team. Joint IP ownership, on the other hand, grants control of the copyright, trademark, or patent to more than one person. With that said, every owning party may copy, recreate, distribute, or wield whatever he wants to do with the IP without consulting the other owners. Thus, business run the risk of exploiting their IP rights in joint ownership. The enforcement of a joint require all the owners participation at all times. So it's very essential to avoid joint ownership because everybody has rights to this stuff, and you can actually run the business down. And then the last slide, which is talking about cases on intellectual property infringement and enforcement. And I'm not going to be highlighting because I know that I'm out of time. Yes, intellectual property infringement and enforcement cases involve violation of intellectual property rights. And there are some notable examples. You can see the case of Apple versus Samsung Electronics, Oracle American versus Google LLC, Tiffany versus Co versus eBay. And the next one, these are our references. the group members, and I'm done. Thank you for watching.
Thank you very much, Akinde Tofumi, for that very, very broad presentation on the topic. And I know very well that the topics that we give the two groups, 15 minutes is not enough to make presentations. Thank you very much, guys, for doing a very good research as a team. I know that you all worked as a team, so thank you very much once again. Without wasting much of our time, I will just call on our mentor to give us a brief comment on the PowerPoint presentation, then we take our questions. If you have a live question, you can also raise your hand. Ms. Omatayo, you are muted.
Okay, yeah. Excellent presentation. Both groups did very well. And I hope you all understood what you presented, because if I'll be judging by the presentation, both presentations were concise. You covered the topics very well. I'd just like to address one thing that, because I'm here to talk to you from the practical aspects, of course. One thing that someone said, the presenter, group 1, I'd like to add that you mentioned computer programs can be copyrighted, right? So here's the deal. In practice, in Nigeria, computer programs are protected by 2 separate IP rights. So you protect your computer programs by joint doing a trademark rights and a copyright, and this is why it's so. Ordinarily, computer programs in the United States, you can, like softwares and applications, you can actually patent them. But in Nigeria, a patent system doesn't allow for that, doesn't recognize that. So in practice, it's advisable that you do a trademark protection of that computer program. Of course, you are doing copyright protection for the program, written down the codes. You know how these tech people do it. You write out codes, you put it all out in writing, or you put it in a disk and register that. But the identity to that particular program, you should trademark it. And when you're doing a trademark, always ensure that you do in at least 2 classes for computer programs. Here's the deal. Computer program, trademarks are, the second speaker mentioned itself. Trademarks are protected according to classes. So in the NICE classification, I'll share a copy of the NICE classification so you understand what I'm saying. I'll share it with Hussein, and he can forward to you all. In the NICE classification, you have groups. The classes are in like about 45. So when you see class 35, it talks about online businesses done online, things that are done digitally. Then class 42 has to do with technologically done, things that are produced or made from technology. These 2 classes, if you get to read them, class 42 and class 45, they can help to protect the identity in your computer program. Oftentimes, especially in Nigeria, from my experience with clients, they would want to just do a trademark protection in one class because of the cost. The cost is the same cost as you are doing a fresh application, regardless of the fact that it's the same or similar, it's the same mark. But the fact that you're doing it in 2 or 3 separate classes, you have to file separately for all of them. But it's your duty as a lawyer to tell them, if you want to protect, you're not doing this protection because you're trying to pass some test somewhere. You're doing it because you are trying to protect your brand. So if you want to get complete maximum protection for a computer program, you need to do in at least 2 classes, class 42, class 35, and possibly one more class that talks about the main what the business is about. So for instance, for a software, let me say like Uber or Bolt, for like the Bolt app, it's an online, it's a technologically driven application, class 42. It's something that has to do with digital. It's a digital business. You actually have to, a program is activated software application. These are things that are done online. When you read the description, the class description, you understand better what I'm saying. So imagine Bolt app trademarked or Uber trademarked in class 42, class 35, but there's one more class, the class that talks about the fact that this business, that's the crux of the business. Yes, the computer program, but the crux of the business is transportation, right? So you have to still look at protecting that particular brand under transportation. Now, this may look a little bit confusing because it's computer program we're talking about, but I'm here to tell you that this is what's obtainable in practice. So you have to do that copyright protection alongside trademark rights protection. That way you've helped your client, you're fully locked in their creativity for them. But that's for Nigeria. If you were to do that in the United States, a computer program can be patented directly. Okay, so that's it for group 1. And then group 2, excellent presentation too. I would just like to address the last thing. I think it was a recommendation you stated, avoid, can you remind me? You said avoid collaboration?
Yes, joint.
You said avoid doing something, ownership, joint ownership.
Avoid joint ownership.
Avoid, okay, so I'd respect your opinion. I wouldn't know why you say that, but I respect your opinion. But I also like to tell you that since you are a lawyer or going to be a lawyer, rather than saying avoid joint ownership, I would say because there are times where joint ownership is inevitable. So how about protect every party interested, every party's investment, every party's creativity by jointly owning this and putting in the right protective mechanisms in place, such as contracts that would govern the application, that would govern their terms and conditions of ownership. Okay, so I think I have to go now, not go, but I'll be around because I'm alone with my baby right now and the nanny is out. So that's it. And so you should consider, okay, I beg your pardon, you should consider advising your clients to do protection contracts that would help the collaboration, because collaboration or joint ownership may not be avoided totally. So that's it. So I'm not saying you're wrong, it's your opinion, but I'm just trying to add that you can actually salvage the situation. Okay, so that's it.
Okay, ma'am. Thank you, ma'am.
All right, thank you very much. I know you can't see me, but I'm still here. It's dark here, so that's why. We've lost our both mentors. Thanks to them for staying with us so far. And all our questions, I myself, I also have questions, and all our questions we sent in, I would send them to our mentors and get a response to the questions, answers to the questions, and send it back to the group chat. Thank you very much, everyone, for staying with us to the end of the session today, and have a lovely weekend ahead. Bye-bye.
Thank you for having me. Bye.